Welcome back to the Save the Constitution series, produced by Robert Welch University. Save the Constitution, Part 3, The President of the United States. Welcome back to Save the Constitution. Last time we examined the functions and powers of the legislative branch under the Constitution. Today we look at the executive branch, as envisioned by our founding fathers. The second article of the Constitution sets up the executive branch, the President of the United States. The executive power shall be vested in a President of the United States of America. He shall hold his office during the term of 4 years, and together with the Vice President, chosen for the same term, be elected as follows. Each state shall appoint in such manner as the legislature thereof may direct a number of electors, equal to the whole number of senators and representatives to which the state may be entitled in the Congress. Article 2, Section 1. The electors shall meet in their respective states and vote by ballot for 2 persons, of whom one at least shall not be an inhabitant of the same state with themselves, and they shall make a list of all the persons voted for and of the number of votes for each, which list they shall sign and certify and transmit sealed to the seat of the government of the United States, directed to the President of the Senate. Article 2, Section 1. The President of the Senate shall, in the presence of the Senate and House of Representatives, open all the certificates, and the votes shall then be counted. The person having the greatest number of votes shall be the President, if such number be a majority of the whole number of electors appointed. Article 2, Section 1. The Constitution then specifies the procedure to be followed in various contingencies. Further, the Congress may determine the time of choosing the electors and the day on which they shall give their votes, which day shall be the same throughout the United States. Article 2, Section 1. Why did the founders provide for a body of electors, the Electoral College, to choose the President and Vice President? Alexander Hamilton observed, "It was desirable that the sense of the people should operate in the choice of the person to whom so important a trust was to be confided. This end will be answered by committing the right of making it, not to any pre-established body, but to men chosen by the people for the special purpose and at the particular conjuncture, time." In other words, the people will choose electors who will elect the President. Why? Why not just have the people themselves elect the President? George Mason, a delegate to the convention, explained why not. It has been proposed that the election should be made by the people at large. That is, that an act which ought to be performed by those who know most of eminent characters and qualifications should be performed by those who know least. He was arguing, in essence, that candidates for the office of president will require qualifications that cannot be understood simply by watching debates on TV. Additional reasons for the Electoral College, according to Alexander Hamilton, are 1. That foreign influence in the election is eliminated because of the temporary office of the electors, and 2. That there is less chance of insurrections among the people because they do not choose the president themselves. A further reason from Hamilton is as follows. Another and no less important desideratum, desire, was that the executive should be independent for his continuance in office. He might otherwise be tempted to sacrifice his duty to his complacence for those whose favor was necessary to the duration of his official consequence. This advantage will also be secured by making his re-election to depend on a special body of representatives deputed by the Society for the single purpose of making the important choice. The founders wanted the president to have sufficient firmness to do his duty and not be so pliable that he would easily bend to the fickle will of the people. Because the administration of the president involves decisions that may not please the people at large, but are the best decisions for the country within his powers under the Constitution, it is important that those who re-elect him can evaluate how he is performing. The founders did not want popularity with the public to be a motivating factor in the president's election or re-election. Elbridge Gerry made another argument against the direct election of the president by the people. A popular election in this case is radically vicious. The ignorance of the people would put it in the power of some one set of men dispersed through the Union and acting in concert to delude them into any appointment. The Constitution sets the qualifications for those running for the office of president. No person except a natural-born citizen or a citizen of the United States shall be eligible to the office of president. Neither shall any person be eligible to that office who shall not have attained to the age of 35 years and be 14 years a resident within the United States. Article 2, Section 1. What if the president dies or otherwise becomes unable to carry out his responsibilities? In case of the removal of the president from office or of his death, resignation, or inability to discharge the powers and duties of the said office, the same shall devolve on the vice president, and the Congress may by law provide for the case of removal, death, resignation, or inability, both of the president and vice president, declaring what officer shall then act as president, and such officer shall act accordingly until the disability be removed or a president shall be elected. Article 2, Section 1. The Constitution then sets forth rules related to the salary of the president. The president shall, at stated times, receive for his services a compensation, which shall neither be increased nor diminished during the period for which he shall have been elected, and he shall not receive within that period any other emolument from the United States or any of them. Article 2, Section 1. This clause was of great importance to the Founding Fathers. Alexander Hamilton explained, "It is evident that without proper attention to this article, the separation of the executive from the legislative department would be merely nominal and nugatory, having no force. The legislature, with a discretionary power over the salary and emoluments of the chief magistrate, could render him as obsequious to their will as they might think proper to make him. They might, in most cases, either reduce him by famine or tempt him by largesse to surrender at discretion his judgment to their inclinations. It is not easy, therefore, to commend too highly the judicious attention which has been paid to this subject in the proposed Constitution. The legislature, on the appointment of a president, is once for all to declare what shall be the compensation for his services during the time for which he shall have been elected. This done, they will have no power to alter it, either by increase or diminution, till a new period of service by a new election commences. They can neither weaken his fortitude by operating on his necessities, nor corrupt his integrity by appealing to his avarice. The independence of the President is crucial to the proper separation of powers." Section 1 of Article 2 concludes with the President's oath of office. "I do solemnly swear or affirm that I will faithfully execute the office of President of the United States and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States." Article 2, Section 1. Taking the oath is good, but it is even more important that he keeps it. We will now examine the powers the President has under the Constitution. The President shall be Commander-in-Chief of the Army and Navy of the United States and of the militia of the several states when called into the actual service of the United States. He may require the opinion in writing of the principal officer in each of the executive departments upon any subject relating to the duties of their respective offices, and he shall have power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment. Article 2, Section 2. James Iredell, a delegate to the North Carolina Convention to ratify the Constitution, spoke about this section. The command of armies ought to be delegated to one person only. The secrecy, dispatch, and decision which are necessary in military operations can only be expected from one person. The President, therefore, is to command the military forces of the United States. The President has not the power of declaring war by his own authority, nor that of raising fleets and armies. The power of declaring war is expressly given to Congress, that is, to the two branches of the legislature. This separation of war powers prevents the President from declaring war on his own authority, as kings often did. He shall have power, by and with the advice and consent of the Senate, to make treaties, provided 2/3 of the senators present concur. Article 2, Section 2. In the Federalist Papers, John Jay wrote, "The power of making treaties is an important one, especially as it relates to war, peace, and commerce, and it should not be delegated, but in such a mode and with such precautions as will afford the highest security that it will be exercised by men the best qualified for the purpose, and in the manner most conducive to the public good." How should we view treaties? Archibald MacLean, a delegate to the North Carolina Convention to ratify the Constitution, told us, "When treaties are made, they become as valid as legislative acts. I apprehend that every act of the government, legislative, executive, or judicial, if in pursuance of a constitutional power, is the supreme law of the land." If a treaty doesn't conform to the Constitution, however, we should consider the words of Alexander Hamilton. "There is no position which depends on clearer principles than that every act of a delegated authority, contrary to the tenor of the commission under which it is exercised, is void. No legislative act or treaty, therefore, contrary to the Constitution, can be valid." To deny this would be to affirm that the deputy is greater than his principal, that the servant is above his master, that the representatives of the people are superior to the people themselves, that men acting by virtue of powers may do not only what their powers do not authorize, but what they forbid. What happens if we enter into an unconstitutional treaty? It would be the job of the Supreme Court to rule that the treaty is unconstitutional. Alexander Hamilton, speaking of the comparison between a law and the Constitution, we can apply this principle to treaties as well, wrote, "If there should happen to be an irreconcilable variance between the two, the Constitution and a given law, that which has the superior obligation and validity ought, of course, to be preferred. Or, in other words, the Constitution ought to be preferred to the statute, the intention of the people to the intention of their agents." Hamilton would agree that any treaty that violates the Constitution is a usurpation of power by the President and the Senate. This usurpation must be curbed by the voters themselves, if the Supreme Court does nothing, by putting pressure on their representatives. The President may be impeached, but the Senate cannot be. Samuel Johnston, then governor of North Carolina, explained who senators are answerable to. "A representative is answerable to no power but his constituents. He is accountable to no being under heaven but the people who appointed him." The Constitution continues with the powers of the President. He shall nominate, and by and with the advice and consent of the Senate, shall appoint ambassadors, other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States, whose appointments are not herein otherwise provided for, and which shall be established by law. But the Congress may by law vest the appointment of such inferior officers as they think proper in the President alone, in the courts of law, or in the heads of departments. The President shall have power to fill up all vacancies of these offices that may happen during the recess of the Senate, by granting commissions which shall expire at the end of their next session. Article 2, Section 2. We now turn our attention to an important role the President plays in the balance of power in the federal government, the veto power. Every bill which shall have passed the House of Representatives and the Senate shall, before it become a law, be presented to the President of the United States. If he approve, he shall sign it. But if not, he shall return it, with his objections to that House in which it shall have originated, who shall enter the objections at large on their journal, and proceed to reconsider it. If after such reconsideration 2/3 of that House shall agree to pass the bill, it shall be sent, together with the objections, to the other House, by which it shall likewise be reconsidered, and if approved by 2/3 of that House, it shall become a law. If any bill shall not be returned by the President within 10 days, Sundays excepted, after it shall have been presented to him, the same shall be a law, in like manner as if he had signed it, unless the Congress by their adjournment prevent its return, in which case it shall not be a law. Article 1, Section 7. In other words, every proposed law must be passed by both the House of Representatives and the Senate, regardless of where the law started. Then it is sent to the President. The President then has 3 choices. He can approve the bill and sign it, thus making it law, or he can do nothing, and the bill would become law without his signature, or he can write his objections to the bill and send it back to Congress. If 2/3 of both houses reconsider the bill, along with the President's objections, and decide to pass the bill anyway, it will become law. The veto power gives the President a defense against the legislative branch, as Hamilton argued, in the case for which it is chiefly designed, that of an immediate attack upon the constitutional rights of the executive, or in a case in which the public good was evidently and palpably sacrificed, a man of tolerable firmness would avail himself of his constitutional means of defense and would listen to the admonitions of duty and responsibility. The veto power allows the President to defend the presidency and the people from usurpations by the Congress, and if he tries to usurp power over the legislative branch, the 2/3 rule defends both the Congress and the people. Further duties of the President are laid out. He shall from time to time give to the Congress information of the state of the Union and recommend to their consideration such measures as he shall judge necessary and expedient. He may, on extraordinary occasions, convene both houses, or either of them. He shall receive ambassadors and other public ministers. He shall take care that the laws be faithfully executed, and shall commission all the officers of the United States. Article 2, Section 3. Cleon Skousen, a constitutional scholar, cited reasons for the President to convene both houses of Congress. The important functions of declaring war, appropriating funds for military action, borrowing emergency resources, and so forth, are all powers which rest exclusively in the Congress, not the President. This provision gives the President the power to call the Congress into action when needed. The Constitution provides a remedy if the President and other officers of the United States overstep the bounds of their delegated powers. The President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. Article 2, Section 4. The power of impeachment is a protection to the people against abuse of power by the President of the United States and other federal officers. The House brings charges, impeaches, and the Senate tries and convicts or acquits those accused of certain offenses. The last question we want to address is, what about executive orders? It is plain that executive orders violate the very first section of the very first article of the Constitution, which states, "All legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives." Article 1, Section 1. Executive orders also violate the 10th Amendment to the Constitution, which declares, "The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people." In this case, any power not given to the President by the Constitution does not belong to him. He cannot make an executive order using a power he doesn't have. If he could do that, why limit his powers at all? Why not simply have Article 3 read, "The executive power shall be vested in a President of the United States of America. We, the people, grant him the power to issue executive orders on anything he wants." Thankfully, our founding fathers were wiser than to do that. We hope you've enjoyed this video on the executive branch and invite you to join us when we discuss the judicial branch in Part 4, the Supreme Court of the United States. If you've enjoyed this video, we encourage you to share this series with your friends and family. Remember our goal: save the Constitution.